what we'd like to talk with you about is something that we've sort of named Code of Disclosure, for lack of a better way to describe it. And there's a question mark after the Code of Disclosure, because the question that we have is whether it is actually a game worth the candle to pursue. And what I would like to do in our discussion tonight is I'd like to tell you a little bit about where this idea came to us from, what we mean by a Code of Disclosure, and perhaps even identify a couple of things that we've thought about on the front end that might be included in such a code. But the overall thrust of what we're trying to do with investigating the Code of Disclosure is to bring in voices from across the world, literally, to say, if we were going to do this, what should we include? So I'll just say ahead of time that although the last slide you'll see is a set of things that we might include, really that's the question that we're asking the group that we want to work with, and that will open up for a larger discussion. And that is, if this is a game worth the candle, what should the elements of the code be? So that's kind of where we're headed. So why a Code of Disclosure? Well, what got us thinking about this, and by the way, the idea of a Code of Disclosure was presented at the conference that preceded the rollout of the Singapore Convention on International Mediation Settlements. And so what we're doing is not a reaction to that, but it's sort of simultaneous with that. And I do have to say that it's some language in the Singapore Convention that got me particularly thinking about this notion of a Code of Disclosure. One of the things that we all, I think, would agree on is that there's a great deal of complexity and difference in mediation styles and mediation practice across the world. Manon Chonville and her co-author wrote a book, and I'm trying to remember the exact title of it, but it was something about like diversity in mediation. And they identified literally dozens of different ways that one could approach the practice of mediation around the world. I helped edit a small book on sulha, which is a traditional Palestinian method of mediation that is very different from what we would learn in North America as part of our basic training for mediation. So there's complexity of mediation. There are tons and tons of ways that people can practice mediation. And one of the things that we noticed that's ODR connected is that it is becoming more and more common for the participants in mediation, the participants in all kinds of dispute resolution, to be no respecters of boundaries. Venue is becoming less and less an issue as time goes by. So it's not uncommon to have people from different venues and different backgrounds engaged in a dispute resolution process. And one of the things we think a Code of Disclosure could do would be to respect the complexity of mediation by acknowledging that complexity and using it as one of the things we talk about when we begin the process of mediation. We think a Code of Disclosure would reduce cultural bias in the sense that it would be transparent, which is the third point, about whatever cultural approaches to mediation are being brought to the table by the third party. And finally, the notion of self-determination, we would argue, is as close to a universal as you can get in the practice of mediation. Self-determination may take various forms, but at the base of it, the notion that you're entering into a process where the parties maintain some control over the outcome and can, in fact, direct the outcome either to a successful end or not, is sort of key to almost all mediation. And to sort of hark back to the Singapore Convention for a moment, the thing that got me thinking about this is in the Singapore Convention, there is a clause which basically says that if there is and I think I'm quoting it almost directly now, if there is a gross violation of mediation standards or practice, then that is grounds for overturning or not honoring an international mediation settlement agreement. And it occurred to me that one could legitimately have a number of different takes on what it means to have been grossly out of bounds in practicing mediation, depending upon where you're coming from. So the initial notion that we had with the Code of Disclosure wasn't necessarily tied directly to the Singapore Convention, but it was tied to the fact that there are many ways to do this work. And anything that we can do to undermine or to underpin rather self-determination is probably a good thing. So that's essentially where we're coming from. So what's the difference between the code of disclosure and an agreement to mediate? Well, practically speaking, in the long run, there may not be that much difference, but the problem with agreements to mediate is that they're almost as diverse as the ways that we approach mediation. Some are very complex, some are very simple. They're not standard across venues, and they're very often guided by local laws, regs, and requirements that may or may not hold up if you cross over venues. Just as a very basic example, if you have a confidentiality statute in one area, and you, in your agreement to mediate, you say that that's my choice of law, and we're going to abide by that definition of confidentiality, and a further legal proceeding after you've made a settlement is underway, and another court in another venue doesn't wish to honor that definition of confidentiality, then very likely it will not hold. And so the local laws and regs sometimes are good to cite, but they don't necessarily carry across borders and carry across boundaries. So what we're suggesting is, what do you include in a code of disclosure? What would it look like? And all we're suggesting is not a limitation on practice and not a limitation on approach to practice, merely a transparency in the way one approaches the parties and describes what's going to happen to them in the mediation process. And so, for example, I mean, these are literally all just examples. You could include choice of law. You could include definitions of conflict of interest. You probably should include what you're comfortable with in terms of language skills. You could probably talk about confidentiality protections, your mediation style, which we very often don't talk about enough, in my opinion, in terms of when we approach the parties. Just to go off on a slight tangent on that, for example, if I'm a very directive mediator, and I've been doing most of my work in, let's say, construction, where they want directive mediators, because if you're not working, you're losing money. So they want someone who will come in and help them get to a point very quickly, understand the language, and move along. I could be a very, very good mediator using that style with those parties. And if I take the same style to another set of parties whose expectation is different, then I'm not going to be very successful. It would be a disservice to those parties if I were not able to reveal to them how I intend to approach this and let them make a choice to use me that is an informed choice and a self-determined choice. Credentials is another thing that codes of disclosure might use, and then items required obviously by local law. So I'm going to stop the screen share and basically just say, what we're talking about is some way to underpin the idea of self-determination, which we think is part of the core of what we do as third parties for the parties who come to us. And so what we're trying to do is put this out as a proposition that we should probably do something like this that, if not universal, would at least be a guideline that could be used across boundaries, across venues, et cetera. So Anna, that's my elevator pitch for code of disclosure, if you want to chime in.
Yeah, no, you cover everything, and just for everybody, I asked Daniel because I'm sure that for all of you it's much easier to understand the English of Daniel without my accent of Portuguese. So it was, I think that the message is much clearer when Daniel give it, and just to for me, I just say this in a nutshell, that this code of disclosure eliminates also the need to unify all the culturally different approaches to mediation. That I believe that is the richness. That is what makes mediation very, interesting and rich as a way to solve disputes. It's about coding the list of topics of disclosure and not their content. So the mediator will just have to tell everybody on the front end what approach he or she is taking, so that agreement on the process a priori can be adjusted, but everybody knows what's going to follow up. So I can be in Asia, I can be in Europe, I can be in US, wherever in the world, I can do different things, honoring the flexibility of mediation, but I go through all these topics. That's the basic idea of this code of disclosure. And we believe with Daniel that it's something easier to do for mediators, no? What do you think?
No. Reactions?
Shall we take the silence as a yes?
Yeah,
Yes,
Jen.
Janet.
Do you think, thank you for your contribution and the concepts. Do you think that the questions you ask to be disclosed are understood in a common way, common enough way?
Could you explain that a little bit? I'm not sure I understand exactly.
When I say, do you practice confidentiality? And they say, yeah, we follow the model rules. Does that have meaning to another country?
Probably not. I mean, and that's kind of one of our points, is that we tend to use a common vocabulary and a common language.
Yes.
But hidden behind that common vocabulary are a myriad of ways of understanding what that vocabulary means.
Right.
And so if I say, yes, I'm going to follow the confidentiality rules or the confidentiality guidelines of the American Bar Association, well, that's great. But if somebody who is in, pick a country in Lagos, I mean, what does that matter to them? And so what you would want to know if you were a party choosing to use someone's services, and that's really what we're aiming at here.
Yeah.
Right? When I approach the parties, I am asking them to invite me into their conflict. And I'm asking them to trust me to run a process that will help them perhaps get to a resolution, but which certainly will allow them self-determination. Mm-hmm. And what I think I need to do ethically is to be able to tell them what they're getting into. When you say yes to me as a mediator, this is what yes means for me working with you. That's really where we're going. And that's a fairly simple concept, but it sounds pretty simple, but it's when you start thinking about it, it's very difficult to say, okay, what should that include?
Yeah.
What's the language we should use? And that's why Anna said, what we're suggesting is not that we should set a script that everybody should use. What we're suggesting is that there should be a framework of things that one would disclose that you would put into whatever language would be appropriate for your practice, if that makes sense.
Yeah, that makes sense. It seems like if there were a diagnostic out there, things that are helpful to think about in terms of disclosure, like you are describing. And if we all took that diagnostic, at least we know what we're talking about by using words. Yeah.
Yeah, and going back to the notion of an agreement to mediate. I mean, I have seen agreements to mediate that are one paragraph long. We're going to meet on so-and-so date, and we're going to try to solve your problem. And the agreement to mediate, for example, that the Community Mediation Center that I work with here in the DC area uses is 4 pages long, has I think it's 22 paragraphs. I mean, it's one of those things where when they say yes to that, they're checking the same box they're checking when they say Microsoft can have all my information, right? So it's nobody's going to read all 22 paragraphs. So there has, in our minds, there needs to be some framework that would regularize what we disclose to the parties for their own protection and for ours. And that's essentially where we're coming from. And as I said, it was triggered by some of the language in the Singapore Convention, but it's not a reaction to that. It's just the thought was, well, gee, that's great. If you're gonna set aside a mediation settlement because of a gross violation of standards, how would you decide what a gross violation is? You have to know the standard.
And the idea was that the variety of unregulated mediation practice and providers create a lot of confusion over what mediation is, as well as concerns about the quality of the services, of the procedural fairness, how mediation was being sold, its impacts to court proceedings. All over the world, we don't have the same idea about these topics. So this is like, you know, I compared it when I was presenting this at the Singapore Convention. I compare it's high quality product, but sells very badly mediation around the world, if we are going to say. And if we, Daniel, when we just think, why that? What is the possible explanation of this paradox? You know, you have an excellent product and nobody buys it, or few people buy it. What's the problem? And after some reflection, we thought that the lack of enforcement of the settlement agreements in the international mediation can be one possible explanation for that. We don't have, like for arbitration, the New York Convention that is there to help all this in an international setting. So probably we're going to have it now with Singapore Convention in some years. But the second thing is often what we can understand all over the world when we go from different countries, the lack of knowledge about what to expect from the mediator. If you go to one country and to another, people can say you things very different. And so if we can manage this in a local setting, in an international setting, it's much more difficult. You need to start to say to these people, look, I'm here doing this. And so this is the idea of this code of disclosure, because we believe that if more people have this common understanding all over the world, they will use much more this excellent product that we believe mediation is. Make sense to you? I see no one that does this, so I'm happy.
Yeah, I see there's a comment in the chat box. A lot of people don't have a high quality experience in mediation. It can be a high quality product and very often is not. And, you know, and I think one of the things that can happen to make it not a good experience, and I've experienced this myself with some of the work that I've done, has to do with expectations. I did for several years, I did a lot of work in labor management, in the labor management field, negotiating fairly complicated contracts in the transportation industry. And we would see occasionally them hire an outsider who would come in to do this very facilitative, and I don't mean this to be a put down, but it's sort of a touchy-feely process. You know, it's a very, very facilitative, very hands-off process. And when we would talk to the parties that we were trying to serve, what they said to us was, look, if you don't understand my business, and if you can't tell me when I'm doing something stupid, what good are you? I mean, why are you here? And so what we want a mediator for is we want a mediator to tell us when we're being dumb and understanding what our process is or what our goal is. And so somebody who is a very competent mediator who could work with one set of parties and have a very good mediation experience, working with those guys is going to crash and burn. It's going to be a lousy experience. And it's a lousy experience because the expectations of the parties are not the same as the expectations of the mediator. And that's really all we're talking about, is a way to rationalize those two things, the expectations on both sides.
And it's very interesting because Alexandre is saying, are you building the standards and soft law for international mediation by adopting a code of disclosure? Is one comment of Alexandre in the chat. And Alexandre, you want to comment or?
Thank you, Anna. But in fact, I'm with the family around, so I'm just listening today and try to participate by the chat. Thank you for the opportunity.
Thank you. And so, yes, this idea of standards and soft law, Daniel?
Well, the question that we started out with when we first started talking about this was, okay, let's assume for the moment that we're wildly successful and people think, man, this is a really brilliant idea. We should really do this. Where would it reside? That is a question. Because if you look at the state of things now in terms of, let's just take certification as an example. Where does one get certified as an online dispute resolution mediator, an e-mediator? Well, there are probably literally hundreds of places where you can get certified. What does that mean? There's no one place that you go and say, that's the Oracle, that's the place. I think iCoder is trying to put themselves in a position to be that, and I certainly hope we're successful. But the question is, where would it reside? And is it something that you would have to regulate, or is it one of those things that would be more like the guide? Would it be more guidelines than standards? Would it be more an approach than a standard? And that's a question that we want to ask as we try to develop these. Bring people together. We're asking two questions, three questions really. One is, should we do it? The second is, if we did it, what should it contain? And the third is, once we've created it, what do we do with it? And so we're just at the very beginning stages of all of that.
Well, Dan and Anna, this is Jeff. As you know, we've been working in the standards creation field with Internet Bar for quite some time. It's the international authorities to adopt something like standards in this field. Well, we all went through the experience with the UN as a regulatory body that might have some say. So the approach in the software area, which has all different kinds of meanings, really at the end of the day, it's all about adoption. You need adoption. If you have enough people that are behind you using the codes that are developed, that's your runway. Otherwise, it's through the international standards organizations. And, those battles are going on right now with regard to digital identity and e-commerce standards. And some of them are in their 10th year already. So our approach is taking this and adopting it. We'll have a summit actually in 2 weeks' time, lost a week there, 2 weeks' time, building the justice layer where, we'll be putting out standards, and in particular, we'll be focusing on digital identity, but we will also be including standards with regard to online dispute resolution, which has a lot of applicability in the area. And right alongside it, we'll have projects where we're looking for adoption, where lawyers and mediators will look at the rules. And so it's really sort of a self-regulatory environment. Nobody's really claiming the space, so we're putting our foot into the space. We'll certainly look at the iCoder rules that come up, and it makes a lot of sense to go with the experts who've created the field, such as yourselves. And so credibility plus adoption, I think, gets us along the way. Otherwise, it's in every regulatory environment, and just take a look at how that all works out in the history of the field. The AAA rules got accepted because they ended up with their contract clause in all the real estate contracts, and then it's just there. But it takes time to get there. So just a thought.
Yeah. Well, there's a comment in the chat box from Nora from India on how are you going to be sure that each concept has a similar meaning across cultures? And I don't think that's what we want, actually. What we want is the ability to describe what the concept means to a particular mediator, so that the individuals who are thinking about using that mediator as their third party understand the approach the mediator will take. And that might mean that, if I'm a mediator who comes, you use the Argentina as an example. If I come from Argentina and my approach is a certain approach, and I explain that to parties who come from Iowa in the U.S. and they don't like that approach, then they can choose not to use me. But what we're really talking about is clarity of description of what you're getting into when you hire me as a mediator. What do you expect from me in terms of behavior and in terms of the way I approach the work that I will do with you? And that can vary greatly across the world. No need for anything to change in terms of that. All we're saying is that if we can create a framework that is broad enough to be adaptable but narrow enough to be useful, then you should be able to describe anything that you're going to do within that framework in a way that allows the parties to choose intelligently whether they want to work with you or not.
And Daniel, probably here I can share my screen and show the slide we prepare and we showed on that presentation, and that speaks about what we ask here, and it's this difference. I think everybody is seeing my screen. Is this difference about a code of conduct and a code of disclosure. And because the question often comes from that. If we have the mission of the code of conduct, I'm not going to read it, it's self-explanatory for everybody. We set out the expectations about the conduct. On the code of disclosure, we set the expectations about what would be the first thing that mediators will do. That's about the behavior. It's just to disclose a uniform set of information that allow and guarantee the party's self-determination. So the content will be defined on that meeting. What we would have is the topics. So the content would be the guidelines, minimum standards of disclosure, and the basis is drawn ethical principles, also prescribing standards for how the mediator informs party about his or her practice and behaviors. What is very different from a code of conduct, where draws the principle prescribing standards of that behavior. So this was the main difference of a code of conduct, that there are several already all over the world, and it's difficult even to compare them, and this code of disclosure. It make it more sense now?
Hi Anna, it's Nicholas here. I think that does make sense because my practice, well, I won't say my practice. I work with the Australian Taxation Office, which is the equivalent of your IRS in the US and other. And we have an in-house facilitation service, which is basically mediation, but they've named it facilitation. And whilst we sort of can express, like you said, the code of conduct, but I take your point in terms of the mission, because one of our parties, we're in-house service, one of our parties is within the organization, and then we have an external party. So it's very important for us to express ourselves and to sort of let the other side know where we stand in the organization, where we fit in, what responsibilities and how we'll conduct ourselves in the mediation, and what role we will play. So we disclose this. But again, what we get when we get feedback is that there's a lack of consistency in this approach from other mediators. So that's going down to the third box where you say where there's no standard of behavior that can be uniform. And we leave it with mostly with the taxpayer, or as you call it, the client, to accept whether they will adopt us as a mediator, given that there's a question of neutrality, impartiality, all of that comes into play. I mean, we've been doing it for the last 6-7 years. I would say probably a handful of cases we've had where other parties have sort of said, no, we're not comfortable with that. But I think a code of disclosure would give a sense of uniformity, especially in situations where we are in terms of in-house services. Yeah. Thank you.
Yeah.
Other comments, questions?
It's interesting, this in-house services, because it was not we did not thought about that at the beginning, you know what I mean? And it's interesting how by reaching out and by speaking about the concept, we have other interests that can be fulfilled by this basic idea. And I agree with you, Nicola, that for some organizations that provide mediation, the fact that they are one part of the mediation, we know that can give problems for the people that are there, that they don't feel that both parts are equal related to the mediator. And that also can be an application of something that will be disclosure at the beginning and that give more trust for the process and for the person. Yes, I really believe that it will allow us to have more trust worldwide on what's going to happen on this room. You know, often I compare when I have been you know, I'm Portuguese and I speak Portuguese, and my main purpose is to have in the Portuguese-speaking countries the level of mediation that has in other countries. And when I was in Sao Paulo, in speaking about mediation with some lawyers, I was just saying, it's just, you know, mediation cannot be a black room where people don't know what's going to happen when they put the feet on the room. It's this transparency that will give more trust worldwide to this process. And this is one way to giving trust to the process, because in a lot of countries, this is already, you know, something, you know what mediation is, people go, and even if we have here on the chat, we have Jamie that is saying, okay, how can we assure quality, a standard quality for mediation, you know, all over, what is difficult. But the main idea is that how can we give more clarity to this process? How can we bring light to this process and knowledge? That's also something that will help on getting trust, so people can use it more often.
So Dan, this is Jaya Sharma. Can you hear me?
Yes, Jay, I can, yeah.
Yes, I have a question. So what do you do in a situation where all the parties are from different cultures or different jurisdictions? And, you know, you may have an international dispute, say, between an American party and a French party, where the legal systems are totally different. One is common law and the other is civil law. How then do you bridge that gap using some of the items you've said should be included in the disclosure, code of disclosure?
Yeah, that partially, in my mind, gets a little bit to practice and how one would implement something like a code of disclosure. For myself, what I prefer to do is I prefer to meet with the parties separately before I meet with them jointly. And this has changed a little bit as a result of COVID, because what I've started doing is running joint sessions with parties who are coming in as test sessions. But I still like to be able to talk directly to the parties without bringing them together first. And the purpose of me doing that in my practice is to say, look, this is who I am. This is how I'm going to proceed. This is what I understand. This is the process I'm offering you. Are you comfortable with that? And if there is a problem, if they're not comfortable with that, they can say to me, no, we don't want to do that. And there's certain flexibility that I have as a practitioner. I don't have to do things the same way every time. But if I talk to both of the parties and have that conversation with them, I can feel reasonably certain, even though they may come from different backgrounds with different expectations, if it's possible for me to adapt my style and adapt my process so that both parties are comfortable, then I have enough information to do that. But the only way I get that information is if I say to them, look, this is my going in, this is what I'm thinking about doing. Is that okay with you? And then I have to react to that, to the response, whatever it happens to be. But for me, the first step for me is always, code of disclosure or not, is always to say, this is who I am. This is what I'm going to do. This is the way I'm going to conduct things. Are you comfortable with that? And that leads to a discussion that then allows me to either figure out that I'm not right to work with those parties, or to figure out the way to work with those parties in the most effective way. And that's really all we're talking about with the code of disclosure, is having some sort of, I won't even say formalized, but some sort of regularized framework that you could use as a template to approach parties to be transparent in the work that you're going to do. That's really all we have in mind.
Can I say something?
Absolutely.
Yes, I like what you were saying. Well, both the thing about expectations and also whether you're the right fit for them. And I just feel that in order to be a responsible mediator, that those are, we need to take the time, which I think a lot of times hasn't been taken. I think online mediation is giving us this opportunity. In every case, I feel we should take the time to talk to them about what are their options with me. You know, I have the ability to do lots of different types of dispute resolution for them. And so I sort of take the opposite approach, not so this is what I'm planning to do for you, but here are different things we can do. I described for them what facilitative, model might look like, or evaluative, or, what exactly is it that I do faith-based. I have a whole way of doing things that way with people. And so it does let me figure out what I can offer to them, whether it's a good fit or not, sort of find out what sounds good to them, because they don't know a lot of times the difference between meditation and mediation,
Right.
or arbitration and mediation. So I like the idea. I do feel, though, that part of this needs to be in every time you go into a mediation. And maybe that's what you do with a code of disclosure. It eliminates a lot of the problem about expectations later on not being met, or people being disappointed. Anyway,
yeah, no,
I've thought about this a lot.
Yeah, no, I agree with you I think I agree with you that it should be part of every opening, put it that way. But the thing that I started thinking about this is that if you want to find a sample agreement to mediate, you can find hundreds of them. If you want to find a sample opening statement, you can find dozens of them. There are all these other things out there, and they come from various different points of view in different directions. But if I'm a new mediator, I just got certified, I'm out there practicing, and I want to get the best ideas about how to do an agreement to mediate, or an opening statement, or whatever, the confidentiality statement. I can find all sorts of places that tell me that. I don't know of any place that you can find that says, okay, when you first talk to the parties, when you're first deciding whether or not you're a fit for them and whether or not they really want to invite you into their conflict, I don't know of any place that you get guidance about that. It's always about the agreement to mediate, which is the conflict has already happened. Basically, they've chosen you already for good, bad, or indifferent, and you give them the agreement to mediate, and that's this 22 chapter document that they sign off on. And I don't think that's quality discourse between me and my client.
I think part of it is an economic issue, and it'd be nice if online mediation leads us to offer our services and not be worried about every minute charging for it and maximizing, the monetary part of it, because it takes time to do this.
It does take time to do it. And, it's, if you look at the brain science behind mediation in the first place, I mean, the way one opens the conversation with the parties has a lot to do with where the conversation can go. And so if I spend some time framing my initial responses or my initial conversations with the parties in a way that validates their self-worth by saying, are you okay with this? And reveals in a transparent way what they're getting into and builds trust, then even before they meet the other party, they're beginning to have trust in the process and trust in me, which is the first step that you need to break down the us and them and make it a joint problem-solving effort. So I don't see this as a soft and fuzzy thing. I think it's really, really important how you begin to talk to the parties. And if there's good guidance on the things that you need to say to them about who you are, what you're going to do, and what they're getting into, I think that serves many purposes. And that's, again, one of the reasons that we were led into talking about this in the first place.
It's interesting.
It's interesting, Jenny, because you were speaking and I was reading what Nora just wrote on the chart. For people to be able to compare disclosures and so choose the best mediator for their case, clients will need to be educated on what each piece of the disclosure entails. And I have never thought like that. It means that, just vision at some in the future. You will have some mediated that will be very clear, and that we state, look, we will start our mediation by looking at the process, by looking at all the options you have as process, as Jamie explained, by looking at how I'm going to deal with you, by looking at what we are going to address, by looking, all this. So welcome. And another that say, welcome to mediation, I am blah, blah, blah. So customer can choose what they want, and it's interesting how this conversation brings us other opportunities for this transparency about what's going to happen. How do I want to project my image to these future customers, and how transparent I want to be at the beginning of all this. And yes, it can be as Jeff said, if implemented, if used, it can be also a way for people to choose you or not choose you as a mediator. Yeah, why not? Daniel, this conversation is incredible. How, you know,
Can I
thank
jump
you.
in?
You
Could I
know,
just jump in, and I'll say that this question of how do we as mediators explain ourselves to the parties, it strikes me, and the parties need to be highly educated to some extent, as Nora pointed out, to be able to understand what we're saying, and we have to educate. It struck me that a lot of the terms that we might use to explain ourselves as mediators to parties were originally written, if you look back to the origins of Len Riskin's work on directive and evaluative and facilitative and broad and narrow, those terms were originally written in order to help lawyers, the educated conflict guides. Lawyers help their parties to select mediators. And that's where this all came from in some funny and odd way. And now it's come kind of not full circle, but half circle, in that we're saying, what can we do from this side to educate parties? And another issue that strikes me in this conversation is that the origin of this idea and this talk that you're sharing is that the Singapore Convention set out a legal standard, and you saw, well, how could we fill in that standard with some content so it would actually be helpful instead of vague and murky? And I find that we're going back and forth between the two sets of interests here. One interest is how to protect a mediation agreement so that it will be enforceable under the Singapore Convention. Right? That's kind of the starting point of this. But in the end, when we keep jumping over to process considerations of how can this serve the process, and I'm pretty sure that in practice, we're likely to find areas where our interests under protecting it under the convention and our interests under running a successful process might clash.
yes.
I wonder if anyone might think of an example of that, because what are our purposes here is something to consider.
Well, while you're thinking about that, Nora posted a comment about parties. I think she used the example of Ecuador, talking about self-determined. They just say, yeah, move along, let's get to the solution.
Right.
Well, they are exercising self-determination when they say to you, I want you to work with me to give me a solution. Right? And as long as they're getting into that knowingly, that's great. Yeah, no problem with that at all. There are other people who would look at that approach and say, no, I want you to shut up and run the conversation and not tell me what I ought to do. So both are fine, depending upon the audience that you're working with. For me, there's a communication theory adage that I love to quote, and that is that one cannot not communicate. And when you begin the first interaction that you have, when you first start working with your parties, you begin to communicate not just the words you say, but many other things as well. And if you have a way to literally transparently say, I'm inviting you into a process and here's what you're getting into. You should understand what we're going to do. And they say, yeah, okay, fine, I got that. And not using terms they don't understand. Being very straightforward and very transparent with simple language about, okay, here's the process you're getting into. Those things, they do, in fact, make it more possible to enforce a settlement, because obviously if that's the agreement that you have on the front end and you do what you said you were going to do, then you haven't violated anything. You've done exactly what the parties invited you in to do. But at the same time, it's a human communication issue as well, a human interaction issue as well as being a legal issue. And I'm not a lawyer, so it's not that I don't care about the legal side. It's I care a whole lot more about the human interaction than I care about that side. Other comments or questions or observations? I appreciate everybody's attention and comments tonight. Yeah, Jane.
Yeah, I just wanted to follow up because I read in the chat about using the terms, that people wouldn't know. I never used the terms. I explained to them just in a conversation. I spent an hour with each party deciding whether we fit with each other. So I know not everyone does that,
Yeah.
That's a luxury I give myself because by the time we get ready to start, they're excited. They're ready to work with me, and we know what it's going to look like. We also know that we can shift. If they decide, for example, if they say, well, we don't want you to tell us what might happen, we just want to get this over with or whatever, they can always decide they want a little bit of evaluation. And so everybody's going to do that differently, but I think that's been my pet peeve for a very long time, that in, say, the commercial mediations that come out of the court when you're on a panel and you're on a list and they bring people in and there's no convening, there's hardly anything that happens before they just get started. And so I think we have an opportunity in the online field to do it differently because it is going to necessarily become more affordable. I don't see, maybe in international commercial arbitration mediation, maybe there are these rarefied places where things are going to cost a lot still, mediation will cost a lot, but I do think there's going to be a lot more opportunities to have it be more affordable for a lot more people. As long as we can get the services part, up and running, enough internet for everybody. But anyway, I know I do it differently than a lot of people, but I never use the terms. I still have to figure out what's what. So I don't use the terms with them. I just describe for them all the different ways. And I also let them know that we're not restricted by what a court would do. That's the best part about it.
Yeah.
We can invent things.
Well, and it's, it is the way one literally engages with the parties. Mm-hmm. And I think that's the training that I've seen, a lot of the training, that's a weakness. You know how to convene, but I'm not sure you talk as much as we ought to about how literally to engage with the parties. And I mean that in a very literal sense.
Daniel, it's Nicholas, if I may add something.
Yeah.
I think going back to the beginning where you mentioned, and I think we've sort of gone down a slight diversion, is the code of conduct or code of disclosure more or less sort of came about in terms of the Singapore Convention, which is basically for mediating sort of international trade between two parties. So, and to protect the mediator and to ensure that the standing of the agreement that the parties have agreed to can withstand any challenge that the mediator was sort of biased in the various factors that fall in through there. I think that approach, I think, is good. I think there is room for that. But then I think as we've discussed here, it's kind of sort of opened the discussion in terms of for non sort of commercial international sort of basis mediation, the utility of a code of disclosure for, if I may call it, sort of your commercial, your non-commercial, your local-based community mediation, and where do you draw that in? And it takes me again in terms, I think, like Colin, mentioned here, like legal language to lawyers in the commercial world would make sense. And you tell them, bang, this is what we're going to do. This is what the mediation is. It's 5 minutes. When I do my mediation, if I have a taxpayer and, tax ones here, we get them from all walks of life, from different cultures. It can take 2 days sometimes for them to get through. And when you start, not because they don't, but just that it's a new thing for them. And then
Yes.
And all the other nuances and variances that comes into play. But also, I think one of the key things that comes in is confidentiality. Confidentiality means many different things to people. And when I sort of talk about it, say, oh, well, whatever we discuss remains in this room, you can't take it. Suddenly I said, oh, but I need to talk to my son when I get home. And, and then you got to then go back to the other party to say, do you agree? So a code of disclosure on those aspects sort of makes it very difficult because there's various nuances to it. So I think I agree in terms of the international one. Yes, it'd be great to have a code of disclosure on that aspect, but how do we work it out and where does it fit? It has to be very flexible for the outside the Singapore Convention.
Well, let me be very clear. The thing that got me thinking about a code of disclosure in the first place was the Singapore Convention. That's what prompted me to begin thinking about it in the first place. But the second thought that I had, and the one that I think Anna sort of picked up on, is that, and just take the United States as an example. I mean, if you're doing mediation in the U.S., it doesn't really matter that you're in the U.S. anymore. It's very likely that you're going to be doing intercultural mediation. Basically, wherever you are, there's probably going to be an intercultural element to what you do. And increasingly, because of our use of online tools, it's also increasingly likely that you might be crossing venues and crossing borders of some kind, whether they be state borders or whether they be international borders or whatever. And I think it's almost a given in most practices that you're going to encounter people who may have varying degrees of expectations about what you're going to do with them when you enter into the mediation process. And so, yes, I think there's this legal issue that's out there in international commercial mediation. That's sort of another whole world. And I quickly sort of got away from that because it seemed to me, as you say, that's a world that in some ways polices itself. I mean, I'm doing some work with arbitration, and there's no secret about what goes on there. People who enter that process know what they're getting into. So our disclosure is about 2 seconds long. It was, hello, let's start. But when you start talking about intercultural, cross-border, cross-venue mediation, I think the way one engages with the parties becomes more important and more messy, put it that way. And I don't think it's possible to say you have to say these things. I do think it's possible to say these are issues you ought to consider when you're engaging with your parties. And that's really what we're looking for, is what are the issues I should consider? And is it going to not be messy? I don't think so. I think it probably will be messy because, and you point out one of the examples that I've run into more than any other, and that is, in the U.S., when you're taught to do mediation, we have this model that says you want to have the decision maker at the table. In almost every culture other than the North American model, it's the family, the community. There are lots of people who have to be involved. You have to have discussions with more than people who are sitting at the table. And we're not really taught to do that very well. And so we have to figure out a way to accomplish that and to make that comfortable. And so those are the kind of things that I think you would need to talk about. But it wouldn't be so much you have to say these things. It's please consider these issues. Please consider these issues when you're talking to your parties.
Yeah, and the idea is to bring on what Nicola said is exactly that, Nicola. It's just to say, how are we going to deal with confidentiality in this mediation that is starting now? Oh, I need to speak with my son. Okay, that's part of our agreement. Do you agree that on this particular mediation, for confidentiality, part A can speak this with the son, and part B say yes. And that's one point of what we are saying about confidentiality for that mediation, and that's clear, and they understood that's for that one, and you get the point, Nicola. It's exactly that, the purpose. So it's not the definition of confidentiality that one of the parties has seen in one dictionary or in a website. Yeah. No, it's for this mediation, this means this, and we agree with that. Do we agree with that? Yes. Great. Let's move it for the next one.
So we're at the end of our hour. I want to be respectful of people's time. Any other last comments?
You talk about the different cultures, and I always feel that, and I do construction, business, all that sort of cultural thing comes up in every situation. You have a contractor, and you have an architect, and you have a public entity, and those are all their own little cultures. And even a husband and wife are, they're not staying married because culturally, they have kind of their own little worldview. And so I like the idea. I hope that I am excited about it. I wouldn't mind being part of figuring out what are those, how would you have something general that you could, and I also think that teaching people, having that be part of the educational process,
Well, drop us an email if you want to get involved. We'd love to have you.
Yeah, that's wonderful.
Yeah, and hopefully you'll hear more about this, because as we gather a little information, we'll sort of put it out there for a wider audience. And if you say, yeah, you're crazy, you don't need to do that, that's fine. If you think it's worthwhile, we'll go forward. Noam, last words?
Well, it struck me, and then as Jamie was speaking, it struck me again that in any other year, I think we probably would have had 3 or 4 sessions on the Singapore convention specifically, and they would have all kind of tied together to flesh out other issues emanating sort of from that, just as your session was. But this isn't any other year. So luckily, thank you, Anna, and thank you, Dan, for not letting us forget the mediation event of last year and keeping it alive, because we'll be back. I want to thank you both. This has been fascinating. This is what Cyber Week was made for. And thank you, everybody, for attending. Thank you for being active. Thanks for saying things like, hey, I'd like to participate, or I'd like to be active. And that is, to a great degree, what the field of online dispute resolution still offers. So much opportunity, so many open spaces, and a whole bunch of really interesting and nice people who are very accommodating to people who say, hey, I'd like to be involved. So be involved. The agenda for the rest of the week is in the chat, just to make sure everybody has it. I'm reminding you that you're all invited to join us on a Thursday night US time for a social hour in which you can get to know each other on a personal level better, learn who's in the room with you and who's in this field. I hope to see you all in other Cyber Week sessions. Tomorrow we have an all-star lineup, as if we could top the lineup we had in this very room. Nuh-uh. But we have Amy Schmitz is talking about arbitration, and David Larson about accessibility in ODR, Zabina Global about open ODR, and I thought, wait, there's one more, Colin and Claire, if there's anyone who has not yet gotten started with online mediation, then that is the session for you. Join us tomorrow. Thank you, everybody, so much.
Thanks, everyone.
Thank you, Dan.
Thank you, Dan. That was fantastic. Great.